made a mistake and inadvertently saw something on the news about this case. I read the newspaper. I had a conversation with anyone about this case. Okay. Call the case again, Madam Clerk.
Yes, sir. Commonwealth of Virginia versus Stephen Rankin. Is the Commonwealth ready?
Commonwealth ready.
Is the defense ready?
Yes, Your Honor.
All right, Madam Clerk.
Would all jurors please stand and raise your right hand? You will well and truly try and a true deliverance make between the Commonwealth and defendant whom you have in charge and a true verdict render of court law and evidence so help you God.
Yes.
You may be seated. Defendant, please stand. Does the defendant wish to have the indictment read a second time?
No.
Ladies and gentlemen of the jury, look upon the defendant and hearken to his cause. He stands indicted for first-degree murder and use of a firearm. He has been arraigned, and upon his arraignment he has pleaded not guilty, and for his trial he has placed himself upon the country, which country you are. Your charge therefore is to inquire whether he is guilty as charged in the indictment or not guilty. If you find him guilty, you will fix his punishment as instructed by the court. If you find him not guilty, you will say so and no more. Hearken to the evidence. You may be seated.
Inquire about why they burned the house. No answer to the court.
You take your hat off, please.
Members of the jury, this case will proceed in the following order. First, the Commonwealth attorney may make an open statement outlining her case. The defendant may also make an open statement immediately after the Commonwealth attorney's open statement. Neither the Commonwealth attorney nor the defendant is required to make an open statement. Second, the Commonwealth attorney will first introduce evidence. Rebuttal evidence may also be introduced. Third, at the conclusion of all the evidence, further instructions will be given to you, after which the attorneys may make the closing arguments and take a big note. Faithful performance by you of your duties vital to the administration of justice. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against any party to this case, for each party is entitled to the same fair and impartial consideration. The law applicable to this case is given to you in these instructions and in other instructions that you will receive at the close of all the evidence, and it is your duty to follow all such instructions. It is your duty to determine the facts and to determine them from the evidence and the reasonable inferences arising from such evidence. And in so doing, you must not indulge in guesswork or speculation. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits admitted into evidence. The admission of evidence in court is governed by what we call rules of law. From time to time, it may be the duty of the attorneys to make objections, and not be the judge to rule on those objections. You must not consider testimony or exhibit to which an objection was sustained or which has been ordered stricken. Opening statements and closing arguments of the attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. No statement or ruling or remark that I may make during the course of this trial is intended to indicate my opinion as to what the facts are. You are to determine the facts, and this determination, you alone, must decide upon the believability of the evidence and its weight and value. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, the relation of the witness to any party to the case, the inclination of the witness to speak truthfully or not, the probability or improbability of the witness statements, and all other facts and circumstances and evidence. Thus, you may give the testimony of any witness just such weight and value as you may determine the testimony of such witness is entitled to receive. The members of the jury to this case is submitted to you for your deliberation. You must not discuss this case with anyone, or remain within hearing of anyone who may be discussing it, and to avoid the possible occurrence of impropriety. I strongly urge and suggest to you that until this trial is concluded, you shall not converse at all with anyone connected with this trial as party, witness, or attorney. After the case has been submitted to you for your deliberations, you must discuss the case only in the jury room when all the members of the jury are present. You are to keep an open mind, and you shall not decide any issue in this case until the case is submitted to you for your deliberations under the instructions of the court. You may proceed.
Thank you, Your Honor. Permission to move about the well. May it please the court, counsel, ladies and gentlemen of the jury. Again, my name is Stephanie Morales, Commonwealth Attorney for the City of Portsmouth. I returned this morning with my co-counsel, Chief Deputy Commonwealth Attorney Cedric Wiggins, and Assistant Commonwealth Attorney Brandon Robleski. And we all thank you for your patience thus far and for your willingness to take on this important job that you are about to do. I stand before you right now to give you a glimpse of what the Commonwealth's evidence is going to be in this important case that happened right here in the City of Portsmouth. This matter involves a first-degree murder and use of a firearm and the commission of a felony. Those are the charges that the defendant has been arraigned on. This defendant, Stephen Rankin, shot and killed 18-year-old William Chapman here in the City of Portsmouth on April 22nd, 2015. And it is the Commonwealth's burden to prove beyond a reasonable doubt that he did this with premeditation and he did this intentionally. Now I'm just going to go through a little bit of what you're going to hear, and I'm going to talk to you about the way the evidence is going to play out. But as you know, it is going to be your duty to do your job based on the evidence as it comes out during the course of this trial. And as the judge stated to you, nothing that I say or nothing that the defense says in opening statements, if they so choose to make it, is going to be evidence in this case. Again, this case is about 18-year-old William Chapman, who was at Wal-Mart on April 22nd of 2015. You will see evidence from the crime scene. That crime scene was at Wal-Mart in the City of Portsmouth on April 22nd, 2015. You will hear from eyewitnesses who were at the scene. One of these eyewitnesses was just as close from the incident as I stand from you right now. You are even going to hear the last words of young William Chapman, words that he spoke to this defendant. You will find out during the course of the Commonwealth's evidence. Our evidence is going to show you that William Chapman had no drugs in his system, that William Chapman had no alcohol in his system. You will learn from our evidence that 18-year-old William Chapman was unarmed during the course of this incident. You will also learn throughout the course of the Commonwealth's evidence about the state of mind of the defendant after the incident. You will also learn throughout the course of the Commonwealth's evidence about the defendant's physical condition immediately after he shot William Chapman in the face and in the heart. You will hear from several public servants from throughout the Commonwealth of Virginia who responded on April 22nd, 2015 to that crime scene. They responded to preserve evidence so that it could be analyzed and presented before the court. You will hear about the results of these analyses from several experts. You will learn many things throughout the course of this trial. And I know all of you are intelligent because we spent a great deal of time yesterday getting to know each other to get this jury selected so that we could do the job that we're all about to do now. After the course of the trial and after all of the evidence is entered, the judge has just indicated to you he will instruct you on the law. This defendant is charged with killing William Chapman with premeditation intentionally, and he's charged with using a firearm in the commission of that felony. And the judge will provide you with instructions that will help you do your job and will help you follow the law in this case. you're going to learn so many different things. You're going to hear legal terminology. You're going to hear technical terminology. You're going to hear scientific terminology. You're going to hear medical terminology. And I have no doubt that you will leave this situation much more knowledgeable than you were before. However, I want to ask one thing of you. I want to ask you that you not check your common sense at the door. This is a very serious matter, but it is also a direct matter. And at the conclusion of all of the evidence, the Commonwealth will return and will ask you to render a verdict of guilty of the defendant, Stephen Rankin, first-degree murder and of use of a firearm in the commission of a felony. Thank you, ladies and gentlemen.
May it please the court. Ladies and gentlemen, the evidence will show you that this was his last resort. The evidence will prove to you that this was his last line of defense. The evidence will demonstrate to you that Stephen Rankin had no choice but to discharge his service revolver, to stop an assailant who was charging him, to disarm him from his own weapon. The evidence will prove to you that at the time that these events occurred, Officer Rankin was in performance of his duties as a police officer. The evidence will prove to you that Officer Rankin, in the performance of his duties, tried to maintain the peace that Mr. Chapman kept fighting. The evidence will prove to you that during the course of the performance of his duties, Officer Rankin gave Mr. Chapman commands to which Mr. Chapman never listened. The evidence will prove to you that during the course of his performance of his duties, Officer Rankin performed in accordance with the training that was given to him by the Portsmouth Police Officers, by the Portsmouth Police Academy, by the Hampton Roads Police Academy, that Mr. Chapman would not follow. The evidence will prove to you that if Mr. Chapman had followed the commands of Officer Rankin, we would not be here today. How did this case start? The case started at about 7:30 in the morning on April the 22nd of 2015. At that time, it was a normal day. It was the end of the shift. Officer Rankin was dispatched to a shoplifting call at Wal-Mart. Routine, no big deal. You'll hear from an individual by the name of Gregory Provo. Mr. Provo was the Wal-Mart security officer. But had called the police and had told them of a suspected shoplifting. Officer Rankin responded, met with Mr. Provo at the front of the Wal-Mart. Mr. Provo pointed out and said, "There's the guy, dressed in this fashion with a hoodie, walking away through the Wal-Mart parking lot." Officer Rankin got in his police car, drove to that location. Got out of the car, again, a routine situation that officers are involved in all the time. Got out of the car, approaches Mr. Chapman. "Hey, you know why I'm here. We need to get your information." Mr. Chapman continues to walk away. "Officer Rankin, you know why I'm here. I need to get your information." Continues to walk away. Officer Rankin takes him by the hand and begins to move him towards the police car, the purpose of which is to get the information from Mr. Chapman to turn over to Mr. Provo. Again, at this point in time, there's no big deal. Routine situation. But when they get to the police car, everything changes. They get to the police car, Officer Rankin tries to bend him over to the car to try and hold him so he can get the information that he needs. Mr. Chapman won't listen. He's struggling. He's resisting. He begins to, as the witnesses say, tussle and scuffle. And this isn't just going to be what the witnesses tell you. Counsel has already alluded to some of the evidence that's going to be present. The officer has a taser. And the taser has a video and an audio that's attached to it. And once the officer displays that taser or engages that taser, it begins to record and it begins to take the audio and video. And you will see that taser and hear that taser. Because on that taser, you will hear Officer Rankin continue to tell Mr. Chapman, "Get your hands out of your pocket. Get your hands out of your pocket. Get your hands out of your pocket." And that's significant. Because to an officer, an individual that has his hands in his pocket is a threat, is a direct and immediate threat to the safety of that officer. And they are trained and they are taught to get those hands out of the pocket so they can see if that person has a weapon. Mr. Chapman won't reply. Says, tase me, tase me. You're not going to tase me. At this point, the officer has tried to control him. He's been unmovable. He's tried to get his information. He won't give it. He's tried to keep him under control. He's fighting, scuffling, and flailing. And so the officer decides at that point that he has to take control of the situation. You'll hear of what's called the use of force continuum. What that means is the officers are taught that for every step that occurs that escalates the situation, the officer takes another step. They start at the lowest force, which is talking to somebody. They move on to the next force, which is trying to take control of them by their hands. And each step along the way, if the person is resisting and fighting, the officer is taught to take the next step in this use of force continuum. And so as Mr. Chapman is scuffling, is fighting, won't give him the information, won't obey his commands, Officer Rankin takes out his taser. Now the taser has two functions. There's a function that you probably have seen in the movies or TV, the prongs. When you shoot the taser, the prongs fly out, they go into somebody, and the electrical jolt them. Well, that's a very serious form of using the taser. Officer Rankin made the decision at that point, it's just a shoplifting, trying to control him. I'm not going to do that. I'm going to reduce the level on the taser. And so he took what's called a cartridge. The taser has a cartridge. He took that cartridge out, which is the thing that expels the prongs, threw it on the ground. Because he didn't want to do that. He wanted to what's called dry stun, which is where you put the taser to somebody, and it gives them a lighter jolt. Again, the purpose is to gain control of the situation and stop it from escalating. And he did that. And at that point, ladies and gentlemen, at that moment in time, when that occurred, everything changed. The dynamics of the situation changed. The dynamics of the relationship between Officer Rankin and Mr. Chapman changed. And it all turned. Because at that point, when he tased him, Mr. Chapman, instead of following commands, flailed his arms, knocked the taser out of the officer's hands, flew 20 to 30 feet in the air on a grass median strip. And you'll see a picture of that taser. And at that point, he hit that taser so hard, it stopped working. It disengaged. The power source disengaged. And it stopped videoing, and it stopped audio. And at that time, the evidence will prove to you that Mr. Chapman turned from a shoplifter to an assailant, to a threat. Because he had disarmed and assaulted this officer. They scuffled, they pushed off of each other. He backed up. Officer Rankin backed up to the front of his car. And the witnesses will tell you he's yelling, "Get on the ground, get on the ground, get on the ground." He's a uniformed police officer in a marked police car. He is given multiple commands. He draws his service revolver. He points his service revolver. Get on the ground. He doesn't want to shoot. He doesn't want to kill. But he has no choice. Because Mr. Chapman doesn't get on the ground. He lunges, he charges, he moves towards the officer. And the officer at that time fired his service revolver. Fired twice. Fired. Second shot, as the weapon discharges, it recoils upwards. First shot hit Mr. Chapman in the chest. Second shot hit Mr. Chapman in the face. And the officer's not trying to shoot him to kill him. He's shooting for what's called the center mass. And you'll hear about these terms. The center mass is the location in the body that the police officers are trained to shoot at to stop a charging suspect. You shoot at the center mass because if you miss, you still have 3 inches, 4 inches on each side by which you can hit the torso and stop the person from charging you. They're taught not to shoot at an arm because you can miss. They're taught not to shoot at a leg because you can miss. They're not to shoot at the warning shot at the ground, because you can miss. They're taught to shot at the center of the mass. And every step of the way, you will follow Mr. Rankin through his training and his experience. And he has followed his training and experience through this case every step of the way. And after Mr. Chapman goes down on the ground, you will hear that Officer Rankin went over and he handcuffed him. Because they're taught that when an individual is a threat to you, you don't know when that threat is ever over. And so you handcuff them to ensure that the threat is eliminated. And then he immediately began performing CPR. He gets on the radio. Man down, man shot, medics, help. Begins to perform CPR with his bare hands. And you'll see the blood on his hands from his attempts to save Mr. Chapman's life. There's another officer, Officer Dykstra, who's on the scene. He comes on the scene and he's walking towards the scene. And he inadvertently kicks the taser. He doesn't even see it on the ground. He kicks it, moves it maybe a couple of feet, length of a stride, towards the direction of Officer Rankin. Miraculously, that turns the taser back on again. That engages the power source again. The taser turns on. And you will hear Officer Rankin say in the background, "Don't die on me, don't die on me," as he's performing CPR. He goes to his car, he gets an oxygen mask, a CPR mask, brings the mask back, puts it on Mr. Chapman, waits with him till the medics get there. And you'll hear the medics say that he was doing an excellent job of trying to revive him and perform CPR. But unfortunately, he died. A tragic loss of life could have been avoided. This will show you Mr. Chapman had only followed the officer's commands. So at the end of the case, the court's going to instruct you on the evidence. The court's going to instruct you, on the law and how to apply that law to the evidence. And we submit to you that the evidence will prove to you that this officer acted responsibly, professionally, in accordance with his training, in the face of an assailant who had disarmed him, was charging him, and was in a position to take his weapon from him. Officer Rankin.